Welcome to The Explainer. Today we're digging into a fascinating legal puzzle from Sierra Leone, where a single comma, written way back in the 19th century, is basically holding an entire country's legal system in a time warp.
So here's the big question we're trying to answer. How is it possible that a modern 21st century nation is running on laws that were essentially frozen in time over 140 years ago? It's a question that really gets to the heart of the country's identity, connecting its colonial past to its digital future. To get to the bottom of this, here's how we're going to break it down. We'll start with the puzzle itself. Then we'll look at the specific law that caused it, called the Reception Clause. From there, we'll get into the weeds of a debate over a single comma, look at the real-world consequences, and finally, explore what the way forward might be. All right, so let's set the scene. The foundation of Sierra Leone's legal system is really our starting point. You see, like a lot of former British colonies, its laws weren't built from the ground up. Nope, they were inherited, brought over directly from England. But here's the thing, this wasn't a clean transfer. Something got stuck along the way. And this is the crucial detail. A specific date was set in the law, January 1st, 1880. You can think of it like a legal time capsule, sealing off a huge chunk of the country's laws in the Victorian era. Just wrap your head around that for a second. The country is being governed by laws written before the invention of the car. It's wild. So what on earth caused this legal time warp? Well, the answer is in a single piece of legislation. It's called the Reception Clause, and it's the legal mechanism that officially imported English law into Sierra Leone. Let's take a look at the exact wording, because this is where it gets really interesting. Okay, here it is, Section 74 of the Courts Act. This one sentence, this is the source of the entire debate. It says that the common law, doctrines of equity, and statutes, in force in England on January 1st, 1880, are also the law in Sierra Leone. Now, that's a mouthful of legalese, so let's break down what it actually means. So that dense legal text basically imports three different kinds of English law. First, you've got the common law. Think of this as the unwritten rules, the law built up over centuries from judges' decisions. Second, you have doctrines of equity, which are basically legal principles to make sure outcomes are fair, kind of like a judicial safety net. And third, there are the statutes. These are the formal written laws passed by Parliament. Remember those three, because the whole debate hangs on them. But, that legal text? It's not nearly as straightforward as it seems. There is a huge, fierce debate raging over what it really means. And, believe it or not, the entire argument, the whole thing, boils down to the placement of a single comma. So, this is the fundamental question. Does that 1880 cutoff date apply to everything, the common law, equity, and the statutes? Or was it only meant to apply to the statutes? And look, this isn't just some boring academic exercise. The answer has massive, real-world implications for the entire country. There are basically two schools of thought here. On one side, you have argument A, the broad interpretation. This side says the 1880 date applies to all three types of law. And, to be fair, this is the approach the courts in Sierra Leone usually take. But then you have argument B, the narrow interpretation, which insists the date only applies to the statutes, leaving the other two free to evolve. And their entire case is built on grammar. Okay, let's zoom in on that critical phrase one more time. I want you to really focus on the punctuation. See that comma after equity right before the word and? Well, proponents of the narrow view argue that this tiny little mark, it changes everything. And this is their big aha moment. Grammatically, they argue, that comma isolates the final part of the sentence. So the phrase, and the statutes of general application in force in England on the first day of January 1880 becomes its own self-contained clause. What does that mean? It means the date 1880 only applies to the statutes, not the common law or equity that came before the comma. It's a tiny detail with enormous consequences. So, while lawyers are busy debating grammar, what does this actually mean for people in Sierra Leone today? We're shifting gears now from the legal theory to the very real, very tangible impacts of being legally stuck in the past. Because the courts usually favor that broad interpretation, that everything is frozen in 1880, the country is operating with a legal code that's over 140 years out of date. Think about it. There are no laws on the books for data privacy, digital contracts, or modern environmental protection, because none of those things even existed back then. This quote from our source material really says it all. The very laws that England itself has long since abandoned and updated are still in full force in Sierra Leone. It's a situation that creates confusion, inefficiency, and prevents the law from keeping pace with society. Now, this all sounds pretty dire, I know. But it's not a hopeless situation. This puzzle actually does have potential solutions. So how could Sierra Leone untangle this 140-year-old legal knot?
According to legal experts, it really boils down to two clear paths forward, one through the courts and one through Parliament.
So, Path 1. The Supreme Court could finally step in and settle the debate over that comma, which could potentially allow common law and equity to evolve with the times. Path 2 is even more direct. Parliament could just pass an amendment to the Courts Act and change one tiny part of the law.
And here is that legislative fix, spelled right out. The proposal is incredibly straightforward. Just amend the law and change the date from 1880 to something more recent, like January 1st, 1990. This single change would instantly update over a century of legal development, bringing the country's laws into the modern era.
And that leaves us with one final crucial question. If the fix is this simple, literally just changing a single date in a single law, why hasn't it happened? Well, that's a question that moves beyond legal theory and into the messy world of political will and priorities. And that is a puzzle for another day. Thanks for joining us.